Today I'll be talking about the case of R versus Suter. In 2018, 2-year-old Gio Monsef was killed when the defendant, Richard Suter, drove his car through a restaurant patio where the family was dining. 3 charges were laid against the defendant. 1. Refusing to provide a breath sample. 2. Impaired driving causing death. And 3. Impaired driving causing bodily harm. However, the defendant did plead guilty to the first count, claiming the reason he did not provide a breath sample was because of bad legal advice he received at the scene. Originally, Mr. Suter and his wife were having dinner at a different restaurant than the Monsef family. He states that here he had 1 drink before they found they were not happy with their food and decided to go to a different restaurant. As Mr. Suter pulled into the parking space in front of the patio, him and his wife got into an argument. He forgot to put the car in park and it began to inch forward. When Mr. Suter realized this, he went to press on the brake, however his foot hit the gas instead. The car accelerated through the patio, killing Gio Monsef. After this incident, Mr. Suter was abducted by 3 hooded men. He was taken from his home in the middle of the night, handcuffed, and driven to a secluded area. Here, they cut off his thumb with pruning shears and left him unconscious in the snow. Mrs. Suter was also attacked in a mall parking lot shortly thereafter. Both incidents were linked to the death of Gio Monsef. At first, the defendant was fighting for a fine and probation. The Crown was looking for a 3-year custodial sentence. The first judge to decide on this case imposed a sentence of 4 months imprisonment along with a 30-month driving probation. Both Mr. Suter and the Crown appealed to that sentence. Unfortunately for Mr. Suter, the appeal court found that the first judge had made several errors in his decision-making. The sentence was changed to 26 months of imprisonment along with the original 30-month driving probation. Mr. Suter appealed to this court as well. The judge emphasized that this was a unique case, and when deciding on a sentence, he noted multiple factors. 1. The defendant entered a guilty plea. 2. He had no criminal record prior and strong community support. 3. He had been employed all of his adult life. And finally, the judge considered the extreme public scorn and threats that the defendant received, as well as the violent actions against him and his wife. The judge decided this to be caused by a non-impaired driver and stated that the refusal for a breath sample was hopefully rare, ill-informed, and bad legal advice. These factors led him to significantly reduce the sentence. However, the appeal court followed a different rationale. The appeal court stated the following. Mr. Suter was acting under a mistake of law when he refused to provide the police with a breath sample. Illegal advice did not constitute a mistake of law, and it could not be used to change Mr. Suter's sentence. 2. The judge did not consider that Mr. Suter chose to drive while distracted. 3. The judge erred by taking the vigilant violence into account when imposing a sentence. Such violence does not take away from state misconduct and cannot change what would otherwise be a proper sentence. These factors led the court to extend the sentence. Without a breath sample, this case was complicated to begin with, and the attacks on the defendant added to this significantly. There was likely no precedent for the courts to follow that would be suitable for this case, so the rationale was very important and had to be thorough. The first judge clearly sympathized with the defendant. His view on the law likely is based more on morality as opposed to black and white rules. I think the defendant should have appreciated the judge's reduction of his sentence and taken it. The appeal court had a more black and white approach. They saw the attacks on the defendant as a separate issue that did not excuse his actions. They also outlined his distracted operation of the vehicle as a much bigger issue, unlike the first judge who didn't even consider it. It is hard to define justice, and many questions come into play in this case. First, the Monsef family clearly ordered the attack on Mr. Suter. Was this justifiable considering the loss of their son? Also, was losing his thumb a big enough price to pay, or should Mr. Suitor receive the same sentence as anyone else would regardless to keep things fair? Finally, do you believe that Mr. Suitor was in fact intoxicated? He may have been claiming bad legal advice as a tactic to get himself off the hook. With so many questions, it is no surprise that different judges and courts would disagree. It all depends on which legal theory or logic you apply. I think both the decision of the first judge and the appeal court were rational and well thought out. In all, Mr. Suitor had no criminal intent. He found himself making a fluke mistake that caused a tragic but unlikely accident.